Hi guys, welcome to the channel again. So today I'm making this video because of one of the subscribers that was just asking me a lot of questions about contracts of lease or lease agreements, and the person wanted to actually know what must be contained in a lease agreement, the provisions, and what some of the provisions mean and so forth. Particularly, the concern was that the year has ended and her contract is about to reach an end, and she has to then um, negotiate a new contract for the coming term. And now the landlord wants to increase the rent with like 60%, and the person wanted to know what should be done in such a situation. And I realized that in the process that a lot of people actually don't even know the basics of what must be contained in a lease agreement. So I want to start by saying that to my mind there are three types of tenants that you find. And one is a tenant who has a verbal agreement with the landlord. Two, you have a tenant that has a written contract, but this written contract was never vetted by a legal practitioner. And the third tenant is one that has a contract that is written, which contract was also vetted by a legal practitioner. So with the first type of tenant is the one that has a verbal agreement, no written agreement. And this is quite problematic to be this type of tenant, because this type of tenant cannot prove the provisions that are contained in the contract. This type of contract is very difficult to enforce, and this type of agreement can really, in the face of dispute, become problematic, because you would struggle to enforce provisions, because you cannot even prove those provisions do indeed exist, and therefore it creates a lot of uncertainty, and in the face of dispute really could easily be found wanting. And then you don't want to be this type of tenant. Then the second tenant is one that is a bit clever enough to understand that they need a written contract, but that they are stingy enough not to utilize the services of a legal practitioner. So they write their own contracts, and as a result, then the contract is there, but then it lacks certain essential provisions that would ordinarily protect them. And as a result of those gaps, there's also uncertainty as to absence of certain provisions, or certain provisions are not clearly drafted, and therefore there is diminished protection. And also because of this gaps, there's uncertainty, and as to how certain things must be done, and if there's a dispute also, the contract is not sufficient to protect the tenant. And you don't want to be, I promise you, you don't want to be this second tenant. And the tenant that I would ideally want you to be is the third tenant, and that is the tenant who has a written contract, wise enough to understand that although it might cost to secure the services of the legal practitioner to look at the contract, that it is cheaper to secure the legal practitioner to look at the contract, protect you as a tenant before you sign the contract. One thing is that if you do not do this and the contract is subjected to a dispute, it would be more expensive to get a legal practitioner to come and fight your battles. So that is something that is important. But with this, the difference with this third tenant is that this is a tenant that understands actually that what goes on into a contract, because the legal practitioner has sat with this person, explained every provision, what it means, the implications of each provision. And this is a person then that's able to exercise her rights, understands what their rights are, understands the obligations of the landlord, and so forth. So this is a person that is definitely much more protected. And that is the type of tenant I want you to be. Be the third tenant. That being said, ladies and gentlemen, let us then go into some of the basic principles that must be contained in a rental agreement or a lease agreement. One of which is the parties. We need to know who is, for example, in this case, the tenant, and we need to know who is the landlord. We need to know the address of the landlord. We need to know the address of the tenant. That is important. Address is important, especially an address in South Africa, because it is important for communication purposes between the landlord and the tenant. The second relates to the description of the property that is the subject of the lease. So this is very important, because if you don't know what you are leasing, how big or small it is, or whether you are entitled to the whole house or just the room, then it becomes very problematic to exercise your rights. And you don't want to miss this clause, because it's very important. And then also what's important is that you need to know the purpose for leasing the premises that you are leasing, you know. So this must be very clear in the rental agreement. And then it's important that you understand the amount, the cost of your of whatever property that you are leasing. How much is it? And also more or less the reasonable escalation in terms of how much percentage will my rent increase in the coming year or 2 years. So that is also very important that you know. And this is very important, because in this case it was a big issue, because it was not stipulated in the contract between the landlord and the tenant the percentage that the rent would increase with in the coming year. And then also the frequency in which the rent is payable. Is it a month to month issue, or is it once every 3 months, once every 6 months? And if this is not stipulated, it's rather important that you then indicate the notice period that one needs to be given by the landlord for the termination of the contract, so that one can then be in a position to go prepare and to seek other alternative accommodation. And this is a very important issue. One issue also that needs to be clear is, when you are going to rent a particular premises, then what is the amount of the deposit? You know, is the deposit 1 month's rent? Is the deposit 3 months rent? All of these things are very important that they be stipulated in the rental agreement. And whenever you get a rental agreement, insist on looking at it and reading it. And if it lacks certain provisions, as I'm talking to you now, that I'm teaching you about, insist that they be included, because it's important that there is a meeting of minds, and meeting of minds can only happen when there is clarity. And then again, so I've indicated also the lease period. It's very important to have a clear agreement as to, is it going to be a 1-year contract, 2-year contract, or whatever length of the contract. And then also it's important that the obligations of the landlord be clearly stipulated. What are the duties of the landlord with respect to the tenant? What are the rights of the tenant? And what are the obligations of the tenants and the rights of the landlord? For example, the tenant must pay rent. You know, he must take care of the property of the landlord, must retain that property in a reasonable good condition. The landlord must ensure that he gives access to the tenant, the use and occupation of the premises, must ensure that he maintains them in a good state of repair, and so forth and so forth. So these are very important issues that you need to be aware of. And then again is the charges that are also payable other than rent, such as, for example, if levies, if there are any, rates and taxes, if there are any. Is the electricity paid by the tenant, by the landlord, or by by the tenant? Water, is it paid by who? All these things are very, very important that they be clarified in the lease agreement. So I've indicated almost 10 things that needs to be um, in a lease agreement. Remember, the parties must be there, the addresses must be there, the type of premises that you are renting must be clarified, the amount of rent, the period of lease, the reasonable increase of rent must be indicated, the deposit, if any, the lease period, if any, the notice of termination must be clearly stipulated, the obligations of the tenant and the landlord must be indicated, the rights of the landlord and the tenant must be there, and then the amount of rental and other charges that includes your electricity and so forth. But then that is not the end, these are the basic clauses that must be contained in a lease agreement, but there can always be more than this to clarify and iron out certain things. But there are certain things that are two things that are very, very important for me that I just want to hold in there as extra for you to be aware of, and they become not part of the clauses within the contract, but they become appendices or attachments to this lease agreement or rental agreement, one of which is a list of defects. So as you go into occupying the new property, obviously the owner would be there, or whoever is the estate agent or anybody else who's going to give you access. Then you start ticking and writing on a sheet the damages. Oh no, the mirror, the walls, the walls are not right, the stove is not right, the door on the cupboard is not right. You mark those so that later on they are not deducted from your rent. That is or your deposit when you leave. That is very, very important. So have a list of defects attached to your contract. And then the last thing is that when you are in somebody's house, obviously house rules are very important. What can you do or not do when you are in the premises? For example, can I break the wall and move it to the other side? Can I, for example, make holes on the wall? All of those things are very, very important. The do's and the don'ts. And that can also be an attachment. And one of the things that is clear is that the landlord has a duty to ensure that all of these basic provisions in a rental agreement are in place. But however, that does not mean that you as a tenant cannot also ask, but insist on these clauses to be included, because it will give you sanity, it will give you peace of mind, and when you have certainty, you have much more confidence to relax. And you know that if there is a dispute, there is a written agreement that you can use to be able to tell your story and advance your cause. So guys, thank you very much, and I wish you all of the best as you negotiate your new contracts for the coming year. And I know now that you understand what must go into the basic provisions of a rental agreement. So all of the best, and thank you very much for listening. We appreciate you. Don't forget to like, don't forget to subscribe, don't forget to actually support us and comment on on the videos that we are making. Thank you very much, South Africa. Bye bye.